Yes. Seven. What you want to withdraw? Final hearing. Please move an application. We will list it. 1007 has to be heard. Yes.
With great respect to the sample court, my lord, writ petition number 24613 of 2023. Though it has been numbered prior to 1 p.m. yesterday, my lord, has not been listed. Medical admission, my lord, already covered orders of the sample court, my lord. Kindly have it at 2:30, my lord. I have informed to Rao.
Yes. Lunch. No, Sarpanch is gone. We have admitted there is nothing right. There is nothing to be heard in this. You file an application for early hearing, we will. You want orders on that application? No.
Yes, sir.
Orders on application for fixing a date.
Yes, sir.
That we will consider. Not tomorrow. Nothing, mister. There are more important things in life than being Sarpanch, right? No. We are telling you, tell your client that there are more important things in than being Sarpanch. Right? He should contribute contribute towards some society. 12-9. We are not hearing it finally, mister. It's only on an application for early hearing. This Sarpanch is nothing. Yes. You know what is it, the merit in the case? You are out of office. Yes.
Medical admission.
Huh?
Medical admission.
What, tomorrow? Today?
Yes.
Today. Medical admission.
Medical admission notice.
How many slips?
7 lots.
No. What is 7? What will Mr. Rao do? We can't take him by surprise.
With regard to the
Tomorrow, 7 matters tomorrow we will take up. What are these matters?
Lordship, so already we could not procure the sponsor letter for C category. Lordship, passed an order to consider them. Lordship, already we applied for B category.
Consider representation, not consider. Representation
for C category.
Similar order?
Similar order.
So then give it today.
May I please?
You give a copy of the order that this order may be passed in all other cases. We will only direct consideration. This is all wrong that we have directed admission and all that. But we have not directed admission to anybody.
Consider the representation.
You are saying that directed admission.
Yes.
May I please note the matter is pertaining to medical admission. Local known. Can you take it tomorrow?
Tomorrow? Not today.
No.
Tomorrow.
Your
Yes.
Lordship,
Yes.
WP number 15117.
Number, forget what is the matter.
This is a medical admission matter.
Fresh matter.
No, my lords. There are 2 orders of your lordships already of the transgender doctor.
So then you file contempt.
We already.
It was before single bench. I filed an amendment because state of AP and Telangana has to be listed on Friday. Relieving orders are issued to the petitioner, and she is directed to join in state of AP. She is working in state of Telangana, my lord.
She has been relieved, right?
Relieving, I challenged the relieving orders, my lord. Lordship.
Monday, 11th.
Obliged.
Lordship, medical admission matter. Similar matters already Lordship passed. Only consider representation.
Similar matter we have dismissed also, right? Today. You know all this thing, right? Mr. All fence sittings, your conduct amounts to fence sitting. We have already taken a view yesterday. That's what we are going to pass all right today.
Yes. To move lunch motion, medical admission, lordship.
How many cases?
3 matters, your lordship.
What is it?
C category, we're not seeking unto C category NRI code.
NRI.
Yes, your lordship.
So what?
Consider the representation of the
Right.
petitions, your lordship.
You give the order also along with your case. When it expired? Expired, then wait. You filed an application? The thing which has expired in 2019, this thing. It will come up next week, no urgency. 13/9. 13/9.
Medical admission, my lord.
Pages.
Yes.
Lordship's permission.
Lordships are taking up page-wise mentions.
No, we have stopped that practice, Mr. You can send your colleague if you're busy. You want an adjournment in some
Yes,
case.
well,
You can make a, because we have received complaints that in the absence of councils, the cases have been got adjourned.
Lordship's permission, my lord.
Liberal view. Third on IA number. One which is third on IA number 1 of 2023. Reasons assigned in the application, common duties for the reasons in this all pro forma manner. You have pro forma. Then delay condoned IA is allowed. And then 2 of 23 requirement of distress with IA is allowed. Third on the question of admission, learned counsel for the applicant submit that the learned single judge ought to have appreciated that the land in question was notified as forest land by notification dated 29/12/1950, and the writ petition was disposed of on the assumption that the land in question is a revenue land. And land in question is a revenue land. What do you, Mr. You accept notice? Accepts appeal is admitted. We can dispose it off also. This has to be gone into, writ petition has to be revived. See, they want to contest, Mr. that this notification 29/12/2050, it's a forest land. The single judge has disposed of on the assumption it's a revenue land. This can't be done without giving them an opportunity to file counter. Right?
Lordship,
If you want to contest, then fine. Appeal is admitted for hearing.
I'll contest only one blood alerted.
We will, Mr. Did you understand? We will set aside the order as per learned single judge, remit the matter to the learned single judge to decide after giving them an opportunity to file counter. If you don't agree for this, we will admit it and stay. Appeal is admitted for hearing.
May I say only one
Notice.
one word, my lord. Only one word. Regarding the opportunity, the learned counsel for the DP raised an objection regarding the opportunity is not given.
There is no question of opportunity to file counter was not given. On instructions, it was decided. Mr. There is a notification. Fine. Appeal is admitted for hearing. Issue notice of IA 3 of 2023. In the meanwhile, operation and effect of impugned order dated so and so, dated. Then don't come up with an application for urgent hearing, right? We are giving you an option to remand the matter and contest before learned single judge. Otherwise, this writ appeal will remain pending. There is a dispute with regard to facts also. We find it very strange. When senior people are appearing, there is a dispute of facts, whether or not they are facts. They will, if your statement is found to be correct, they will be prosecuted. If your statement is found to be correct, then you will be prosecuted.
Your lordship, just a moment. One moment, your lordship. Initially, they are not included managing committee. When the this implication are not in the lower court, your lordship. What has happened? They are not in the lower court, your lordship. And this matter,
Which lower court?
sorry, I'm not.
Can you address the
My apologies, your lordship.
appeal jurisdiction?
My apologies, your lordship. My apologies.
Mr. Your parties or not? You have said that we are not parties. And what is to be done? Don't tell us. We are the judges.
It's a case blood, no opportunity have been.
Were you parties before learned single judge? Don't tell us what is to be done.
We were not the parties. We were not made as parties.
Mr. Will set you back. Right? The acting court, it has to be remanded. Who are you?
Sorry.
We decide and what is to be done. So we terms to the court. This is not taken in good spirit, Mr. Don't try to dominate this court.
Sorry.
We will see to it that you are putting your right place. Never again do it.
Sorry, ma'am.
Were you parties in the rate petition?
No, my lord. Okay.
Yes, past. What are your names?
At page number 54, my lord. The impugned proceedings at page number 54.
Subsequently, the learned single judge ordered to implement the respondents, that's managing committee. He filed an application hearing IN number 2 of 2022, which was allowed
Yes.
same day.
They are setting aside the order, remitting the matter. Order sheet doesn't indicate that they have been heard. In pursuance of an interim order passed by the learned single judge, they were impleted. This is what you are required to say. You are not saying that. So you've got it. You say if you don't assist, then also we get it, right? Yes.
We have
This Indra court, they have not been heard, Mr. The order sheet doesn't page 12 of the paper book you see. Their presence is not, the order says petitioner, government leader for minorities, Mr. Abu Akram, learned standing counsel for work board. They have not been heard.
well, they failed to appear before the honorable single judge. Well, it's not fault of
Have you been served? They have been
they have been served with the notices.
then, Mr. You are absolutely actually this thing, and you will be held up. No, you will be held up for making incorrect submissions. Right? No. Sorry, means we are granting him time to produce that whenever you serve file and affidavit. Either of you will go to jail. Yes. From here only. Yes. This inter-court appeal has been filed against an order dated 18/7/2023. 18/7/2023, by which the election of managing committee of managing committee of what board?
No, that was constituted by work board.
Huh?
Managing committee constituted by work board.
Managing committee constituted by by which election of managing committee constituted by the work board has been set aside. Paragraph. It appears that the appellants were implemented as respondents in compliance of the order dated 18/7/2023 passed in IN number 2 of 2022. Paragraph. Learned counsel for the appellant submits that appellants are the managing members of the managing committee whose elections were set aside by the learned single judge without hearing them. Paragraph. On the other hand, who are you?
I am appearing for the petitioners and the petition
On the other
respondent.
hand, learned counsel for respondent number 1, stroke petitioner in the writ petition submitted that respondents number 4 to 10, namely the appellants, were served with the notice. However, they failed to appear, and therefore the learned single judge has set aside the thereafter only an order dated 18/7/2022 has been filed. Full stop. Paragraph. Learned counsel for the parties are granted 2 weeks time to enable them to file support affidavit in support of their respective stands.
Meanwhile, suspension of the order. Meanwhile, suspension of the order.
Mr. You have filed an application seeking leave. That is misconceived,
This one.
right? Because you were parties in the petition. Guilty of misleading the court and making false statement properly on facts. Sit down, madam. False statement. So therefore, we should have dismissed your appeal right away by imposing cost of rupees 50,000.
I have not given false statement. I'm sorry, madam.
You have filed an application, you have filed a leave petition. You are parties in the writ petition. Can you file a leave petition? Who filed?
We were not the parties.
Yes, said, Mr.
Let them file the proof of service.
That's why
Yes, yes.
he is filing an affidavit stating that you are respondents 4 to 10 in the appeal, in the writ petition, and notices were served. to
Please,
you.
madam, please.
In the meantime, may I request your lordship
Nothing.
to look for the
File an
records,
affidavit.
for the records of writ petition So that, my lord, the cat will be out of the bag.
No, you file an affidavit.
I'll also file.
Please file.
I'll also
Records
file
of
my
WP
certified
number.
copy of the
Records
order.
of- Records of WP number so and so be tagged with the writ appeal list on 13/9/23, 13 September.
I'm permitted to take back my certified copy, my lord,
Uh-huh.
of the order.
Certified copy.
Yes.
Please take it. It is surprising, amazing, mister, that despite you telling this thing court that he has been impleaded, he still maintains that I am not a party. So thereby ensuring that we initiate contempt proceeding against him on the next date. Mister, it may be a mistake also. He is showing the cost title. At least verify the record. Let him submit. You also inspect the record. Let him submit. We have asked you to file an affidavit also.
My learned friend failed to
Please
obtain the
understand.
certified copy of the order,
All
and
right,
he was
next
under
case.
the impression that
Next case, 13 September. It is unproductive hearing, so it has been adjourned. There is nothing to hear now. Yes.
deeply obliged.
Yes. Examine the record, mister. You have filed an appeal and we have asked you to file an affidavit. Please do so. Examine it and then, yes. Mr. Rao,
GMS number 72, tomorrow,
72.
batch is coming tomorrow.
Ah. In this writ petition, the challenge has been made to validity of Rule 32H
Yes, sir. Yes.
of Telangana so and so rules 2017. Line below, similar writ petitions have been posted for hearing to 3/8 to 12, 3/8 to 12, the applications were required to be filed.
Required to upload, yes.
Did you do it?
The petition before lordship uploaded in respect of A category. B category. Now, the petitioner under impression that he is going to get the A category. Unfortunately,
He did not get it.
Yes.
Now you will get
Is-
it. No, Mr. Rao, now you will file for B category, you will not get it, then C category. And D category, E category, one by one.
May I request that apart
So
from
it's
the
up to Mr. Rao. We don't know,
Petitioner-
last date is over.
petitioner file the application, the petitioner file the representation before the respondent. Similar circumstances, this honorable court. Page
And
number
that will be,
yes, page number 29. Page 29.
39, 31 order, yes?
Yes.
All right. Oh, same, you are the counsel in that case also.
Yes, ma'am.
Same order. You should say that same order. All right, page 31, same order, certified copy. Yes.
And these are last. Petition filed for set aside the order dated 5/8/2023, my lord. But the respondent has issued notice to the petition, my lord, allowing selling in the entire land 9.20 guntas.
No. Appeal under section 17, Satyavati Tandon and thereafter judgment. This is a measure under 13(4). We have held that you should file an appeal under section 17 before debt recovery time. The petitioner who is a borrower
I
in
bring-
this,
Yes, my lord, I bring before the sample lordship for the,
no, nothing, lordship. This is,
you permit me for the, petitioner is ready for the entire amount paying, my lord.
you see this order, it binds us. In the action of the respondent bank in issuing a warrant to within number 2019 dated 37/2023 and comma B against the aforesaid order and appeal lies under section 70 of the Surface Act. Full stop. And this WP number 20342 of 2023, paragraph 5, 6, right? Then para 7 with the from here, this is it. All right. You take You have this. Next.
This matter pertain to the GOMS number 114. This honorable court pleased to pass the order in batch of petitions, my lord.
No. See, Mr. Nageshwar Rao, yesterday we have passed this order. Please see.
My lord.
Please see, this view has been taken. Please see. Then argue. We will hear you. Please see this order and then.
My lord.
No, please see the order. Please go through. We are giving you time.
My lord, it will take some time, my lord. Lordship, so please kindly take up tomorrow, my lord.
Tomorrow. Learned counsel for the petitioner prays for adjournment. Can you give that? Give one photocopy to him.
Yes, my lord, I will take.
Give that copy. Give that. No, please give it to us. We don't have a copy except this. We are telling you that this order binds us to what it is that you were declared non-local on 2/8/2023. Right? Thereafter, you were sitting and waiting the proceeding, watching the proceedings. Your others who appeared similarly situated approached this court, challenged the rule, and then we passed an order on 2019. Thereafter, you filed a petition. So we have denied the benefit on the ground that it suffers from delay and lapses. That is the judgment. Well, you are seeking the benefit of the judgment. We have said three Supreme Court decisions we have relied: 2012 7 SSC, 2021 13, and 2015 1. 15 SSC to say that the extraordinary discretionary jurisdiction under Article 226 cannot be invoked in favor of a person who sleeps over his right. This is the judgment.
My request, my lord. Poor students, my lord, what are having allowed this, some of the cases, my lord, by the honorable.
No, you submitted a representation with regard to your grievance, and that he can decide. That's different.
Yes, sir.
He is still no. If there is a petition, immediately seek the declaration, the petitioner will seek the action to the university to treat him as local candidate. No, it is a petition from the petitioner, the petitioner is eligibility of new rules in the Telangana medical and dental colleges admission within admission in MBBS sources rules 70 and action to respondent to treat him as a candidate and to admit petitioner admit the petitioner MBBS MBBS paragraph. Mr. What you said yesterday is which we discussed the petition.
Yes, sir.
Has already made down to 3 number three, bracket from uh, number three and B. B of the rules and it is also contained at the teacher the permanent resident of state of Telangana. It is also it is also submitted at the teacher to submit representation with regard to the university and university be directed to decide the representation which may be submitted by the petitioner. Paragraph. On the other hand, learned counsel for the university has submitted that in case such a representation is submitted by the petitioner, form of the same shall be decided in accordance with law within such time limit as may be fixed by this court. Paragraph. In view of such submissions and in the facts of the case. Just that. And petition is not on question of admission law. It submits that the that have had of petitions in which the validity of the rule in so far as it pertains to levy of license fee. In which so and so levy of license fee by GOMS number 147, was challenged, has been entertained. And an interim nothing was titled 32 days interim 32 34. This is your the by respondent of making any of the trade license fee from the petitioner will be administered petition list for and purpose in W number 1 double 2023.
Previous things not my actually also as the representing, but Milad, I would like to bring one aspect in that. It has been expressly allowed by the MCC bulletin. Need to bulletin aspect.
Why you not submit an application between if you're asking that we have to type of things. That is representation. Right. Is this what candidate We have structure, but it has to be given time to file counter or not. What what's it? Action whatever they decide to be are not saying any member. Is that I think this thing which order? There is no order. So
I'll pass on that. Sorry,
petitioner in this petition has prayed for following reliefs. Learned counsel for the petitioner submits that that with regard to his grievance, the petitioner submitted a representation to the petitioner in accordance to sufficient facts for the case. The petitioner is of the patent reported to consider the representation submitted by the petitioner within a period of 2 days. It may be that this focus on knowledge. However, he failed to indicate options and is therefore not entitled to participate in the next council. However, he submits that the representation shall be decided. So, this yes. They all understand it, but if you go yes, 11. Which page?
Page 30 or
Teacher has paid for the following and it comes to the petition submitted and that this thing. You have submitted representation September 20. And repetition of the same order. Then on the next 6 submission and just wait to exercise and they no time. 2 days certified copy. Yes. Smaller. Yes. Say more. 13. Representation for this condition is recorded that you are not free. No, and this can be it's to ready for an order which you have not yet that is yours. Say order. Certificate copy. Yes.
From non-local to local, same item number 6 order. Item number 6 order.
6 order. Item order.
Same order, non-local to locally allowed.
Consider item number 6, madam. Certified copy today.
I have not submitted the representation, my lord, that liberty may be granted.
Petitioner be granted the liberty to submit a representation and the writ petition be disposed of with the direction to the university to consider the representation submitted by the petitioner. Then, right. All right.
It's also regarding.
We should go, no? How
Same order.
civil right?
I have to take
Same order. Representation.
Item 6 order.
Item 6 order, right? 16.
Permitted make reference.
Yes, yes. Permitted to make. Yes.
Similar orders for passing item 11.
Item 11, madam. 17, 11, right. Yes.
The petition,
Yes.
the petition is not being allowed to participate in the second round of housing.
Why?
I made a representation regarding the petition.
Representation. Mr. Rao,
Representation.
where is the order?
I filed in page number 27.
27.
In this case, my lord, representation is not filed. In my case, my lord, I have filed.
And nobody is there to deliver copy. Yes. 20.
To consider the representation of the petitioners, my lord. Representation is page number 17 to 19, my lord.
Which order? Mr. Rao.
Order copy has been notified, my lord, to consider my representation, my lord. Dated
Same order, Lord.
38, 8 of
Which same order?
Same order, Lord. That same order as that of Lord, 11, item 11. Item 10, Lord. So this one, item 11.
Item 12, no? Item 12, same order.
Same order.
20, item 12.
here in this matter, my lord, to consider in the C.
Yes.
Already in this matter, also, my lord, we missed web option, your
Which
lordship,
one?
my lord. Yes, my lord. We have missed web option, my lord, same order, my lord, just now lordship has passed.
Which case?
But item number 19, your lordship.
Item number 19, ma'am.
Yes.
Same order, certified copy today. And 22 and 23 also.
22, your lordship.
Ah,
Same order, my lord.
that's
For
what.
A category, my lord, mop-up round I am seeking, my lord. I have missed in A category, first round I have missed, my lord.
Prayer, right? Vote his prayer and then submits that writ petition preferred will be decided.
Same order, Lord, that I stated so, Lord, he has not exercised.
Except web option.
These are
Submission not exercised web option are disposed of. Yes. 23.
20. My lord, in this matter, your lordship, my lord, I am seeking to be, my lord, considered as C category, my lord, C NRI quota, my lord. Already I have read.
Prayer, madam, prayer clause and then submits that the direction we issued to decide the representation. All right, disposed of. Certified copy today. Yes.
Lords, item 24 to 27, my lords. AG is appearing requested password, my lords. AG is appearing requested password, personal detail.
What is it for orders? What order? All right, password. No, 22, 24 to 27, but '28.
Lord, there's a case where 9-2 was being invoked, saying that I have not invoked arbitration.
We'll admit it. No. We'll admit this. This is to be heard. 23 appeal. Appeal is admitted for hearing.
Appeal for the respondent. My lord, I am restrained by way of an injunction against the alienation of the property.
Please file an application for early hearing, right? We will hear it.
But in fact, this matter was heard in part, my lord.
But we have forgotten everything about it. Like long back it was argued. See, that's why. How much time will it take? Half an hour, 45 minutes easily. We don't have that kind of, see, we are under this thing, professional, this MBBS
Yes.
course. We have to deliver judgment also. Then all these cases, lunch motions are coming.
Yes, my lord, last time responding to client file counter.
Ah.
It was sent by email about 11 o'clock in the night.
Who?
This morning.
Counter to this commercial appeal.
Yes, section 9, but it's appeal. That's it one.
Nobody is there. Mark is present.
I'm appearing in the matter, Lordship.
Yes.
Lordship, I filed the counter today, Lordship.
Huh?
I filed my counter, Lordships, today. And
Today? He is filing today. Learned
filed, Lordship.
counsel for respondent submits that he shall file counter to IM1 of 2023 today, list after 1 week. Yes.
Last matter Tuesday, my lord.
It will come up after 1 week.
It's the 13th. 1 week.
1323 appeal, not because see, we have been telling all of you that there is a now auto date system. Till the date, it's not that after we it's after 4 weeks. Nothing of this. System will be a date, it will come on that day. Your juniors, 4 of them are there. Yes.
These two topics in first matter, this delay of 246 days, and in one matter, the delay of 245 days. The explanation is lost. The first of the two matters, you are not published the petition.
Yes, I don't think you will oppose the delay.
Lord, not really, Lord, but the background of operation of SAR. So therefore, it may be taken up.
Some audio problem, audio problem, we are unable to hear you.
I'm talking. Also, can you hear me now? Can you hear me now?
No. Yes, Mr. How do you take up continuation delay?
Let me
They are there will be a operating against you. If you control the delay,
what I'm submitting is they can go ahead with the arguments along the return.
the business so that it's appear to be noticing a voter on account of some people which this group was unable to hear the submissions of the senior council. This nature. Yes. Model petition. Yes.
I request will tomorrow let it start also.
Not there.
I am there.
Then some other court. Not tomorrow. Tomorrow is medical batch 6th of September. Mr. Rao will argue.
any other name that, because there are 230 matters specifically we listed before.
So we don't know, it may come before 2:30 or otherwise you can still time. Yes. It is for admission, Mr. What is it for admission?
My lords, the register issue, my lords. My lords, have directed me to file the affidavits of the individuals who have made entries in the register.
Have you done it?
But I have filed the affidavits.
Affidavits.
That's it. But I'll prepare the synopsis and I'll make my submission to the.
No, we have already dictated everything in the order. No synopsis required. We know that the senior counsel is paying, we had heard her at length and then spent considerable amount of time, 40 minutes on the first dates.
Yes, sir.
You remember?
Yes, sir. Let the senior counsel appear.
Also, yes.
May it please your lord. My lords, this is that matter where your lordships are pleased to hear it. We, Mr. Sriragram and I are trying to broker peace between the husband and the wife.
What happened?
And we are both hoping that it will be done in the next weeks, my lords. Your lordship may.
Learned counsel for the party jointly pray for and are granted 4 weeks, 6 weeks further time to enable them to report settlement. Interim order granted on earlier occasion shall continue till next date of hearing. Counter not filed.
I'm appearing in the next matter, 35 minutes for the
Petition
petition.
is admitted for hearing. Let counter if any on behalf of. One minute. Your grievances still subsist.
Official respondents already filed. Confirm
There is
that
some
the illegal
problem, right?
transactions have been taken up.
You call the CPC or someone, there is this, why
Inaction,
nobody appears or respond to.
I did the respond number. The station was on this formal part.
Item 34, lordship.
Counter is admitted for hearing. Counter if any on behalf of the respondents we filed within a period of 6 weeks. The HMDA shall also report compliance with the directions issued by a bench of this court on 29/7/2019. Admitted for hearing.
Lordship, item 34, lordship.
I request voters to fix any date.
We are unable to hear you, Mr. We have granted you 6 weeks time to file counter. If you don't want, let them not file counter. Be happy. The effect is of government's mediation by then the petition and objection is taken appeal that we are not being given an opportunity to file counter. But they don't say no, that you do that. We cannot respond much to your writing. We cannot allow this today because it is what will accept ground one listed for admission. Secondly, on account of technical glitches, I was not able to log in before the early opportunity of hearing was given before allowing the petition. And how will you defend the order? Then this will come in the admin of the list or remand from Supreme Court. You don't want that, right? Yes. Within 6 weeks.
Item 37.
Item 34 may be permitted for withdrawal.
We are unable to hear you. Some problem. Nothing, Mr. Nothing has been done. It has been given. You have been given 6 weeks time to file counter. No effect. You want to file the petition.
I want to withdraw 34 lordship. Item 34 withdraw lordship. Permission may be granted for withdrawal.
We are unable to hear you, Mister. There is some logging again. We can't hear you.
I am seeking withdrawal permission lordship. I am seeking withdrawal permission lordship.
Which petition he wants to withdraw?
Item 34 lordship. Item 34.
Before you want to withdraw,
Yes lordship. I am for
if
petitioner.
somebody else was appearing, he has gone away. 34, somebody, some other council was appearing.
He was responding.
45.
You are appearing on behalf of whom in item 34?
I am for petitioner lordship. I am for petitioner.
Right, Mr. We are saying withdrawal, which you can withdraw, right? We are unable to give you. Some other council has appeared on behalf of petitioner. We are admitting the petition, granted 6 weeks time to file counter. If you want to withdraw an application, get mention number. We are unable to. We are telling you repeatedly. What you are saying is we are unable to.
One name is appearing in the letter.
Bank is not appearing.
Bank Limited.
Bank is not appearing.
My lordship, I am appearing.
Krishna Chaitanya Millet, I think it is.
Krishna Chaitanya. He is there.
I am appearing for the bank lordship.
Mister, do you want to say that all do you want to tell us all councils have problem in their end? All councils.
My lordship, I am appearing for the respondent bank lordship.
Yes, what do you say?
My lordship, the order has been complied.
So we will see, Mister. We will this thing allow this petition, and since he has complied, and don't be delaying in depositing the payment, and ask the DRT to decide his appeal.
Yes, lordship.
Correct.
Yes.
Yes. Yes, madam. Mark the presence. With consent of the parties, the petition is heard finally. In this petition, the petitioners have asserted the value of the order dated Hyderabad under Section 17 of the Service Act. Right, even after referred to as Service Act. Which by the rules by the appropriate order, the title was rejected the application for the petitioner seeking extension of time with compliance of the conditions contained in the order dated 24/3/2023 with regard to making deposit. With consent making state consent to the parties back is good night. This ability after this up to the after this factual has been right. End of the scope by an order dated no this scope by an order dated 9/8/2023 and the petitioner paid a sum of rupees 50 lakhs in compliance with the official order, the petitioner has paid petitioner's deposit amount of rupees 50 lakhs recovery with the bank continuation comes from the petitioner submits that the petitioners have their control their profits and circumstances beyond their control. There was approximately 45 of submission and taking into account and the additions in the operated 9 issues operated 2023 passed by this the order dated so dated 2023 first by the tribunal and delayed in making set aside the delay in making the uh, deposit of amount as directed by the debt recovery tribunal is controlled, controlled, full stop. The debt recovery tribunal is further directed to decide the appeal preferred by the petitioners expeditiously, line below. Accordingly, the credit petition is disposed of.
I'm obliged.
Yesterday, I was directed to provide the registration documents, Lordship.
Ah,
In the time bound only, I filed my registration.
additional documents, what additional?
B category.
Ah,
48.
no, see, Mr. Wait. No, not here. The filing section,
Yesterday.
not here. You file in the filing section, we will call it. Pass over, pass over. Pass over. Be here, Mr. Otherwise, if you don't hear it, not here in pass over round, you go ask your colleague to file it and hand over then. And we will not permit filing of this applications here. Pass over.
With regards to local, non-local, challenge to that 3 subparcel, 3 of
Yeah.
114, Your Lordship.
Yes. So
Shortage
we
of,
have passed an order in Mr.
Item 6, my lord.
Item number 6, same order.
maybe.
In Mr. P. N. Rao's case.
Yes.
Item number 6, that madam was there, no? Same order. Petition is disposed of, certified copy today.
Permit to make my representation also.
Ah, yes.
Yes. Applies.
Petitioner shall be permitted. In case petitioner submits a representations, the order is there already. We have dictated. Yes.
May I please, Your Lordship?
Yes.
From yesterday, the matter is posted
Ah.
today, my lord.
Ah.
The Lordship was pleased to direct me to file additional affidavit because the
No,
explaining
see,
the
Mr. We have passed an order today in all the cases.
because it's a question of local law.
We are, this thing, Mr. There are two courses of open to you. The order which we have passed in all other cases permitting, directing the university to decide your representation. That is one option. Otherwise, you argue on merits and explain delay. Get an order on merits. So there are not these two options in the beginning. In case you act on the first option, then
I will go with the first option only, my lord. Item number 6.
representation, which is the
I of the students, my lord.
item 6.
I will take, my lord. Order copy, my lord.
You did not say, Mr. All these people are very sensitive and they type it up. You did not say.
I'm sorry.
Certified copy to date is given. And all these are limits uses, right? It is good that you opted for Mr. Prabhakar Rao is more magnanimous than us. So he will consider it quite the grand.
Yes, my lord.
He will consider.
We need to apply for that, my lord, because
Let me. It is the case of issues that for the of 6 weeks. Teachers that prepared for every accountability on behalf of respondent to be filed within a period of 6 weeks.
Daytime for around 6 weeks.
For the same amount of 6 weeks, accountability on behalf. 6 weeks. Yes. Yes. What happened? How much time it will be completed now?
But 15 of this month.
Market presence, whatever. Learning council for learning government teacher for higher education that the construction in question shall be completed on or before 15th of October 2023. Stop status report is disregard. With regard, no, an affidavit stating that the construction has been completed shall be filed before this after 6 weeks. Unfortunately, counter you have to file. Unfortunately, we are not saying counter you have to file. Which the three cases. So number 10 also. Uh, she has filed a petition also. She has filed a petition. In that you have filed a counter. That I have not filed, but since you are directed me to file an action taken report. No, so motor case. With all the allegations made in the petition also. But you have to file a memo. I'll file a memo. I'll file. We should not tell you what you should do. Don't file. You have done it everything in so moto. We will pass an order in so moto and in rate petition we will say all allegations have been admitted because they don't want to contest. I'll file it. She is praying for compensation. We will award. I'll file it. I'll file the memo today itself. I'll adopt it. Counsel for respondent submits. Counsel for respondent submits that he be granted the liberty to file a memo seeking adoption of the counter filed in suo motu WP number 10 of 2023 within 3 days. Let a copy of counter filed in suo motu WP 10 of 2023 be supplied to learned counsel for the petitioner in WP number 323092/2023. Additional material petition, fixing an early date. What is the urgency? You have been restrained from interfering with the possession of petitioner's property. Yes, sir. You want to interfere. No, that's why
Initially, the repetition, we filed the repetition, we succeed in the repetition. Against which the
government has already been admitted for hearing. Has it been admitted for hearing?
Appeal was admitted for the and it's however final hearing now. There is an interim order which is there in the favor.
That's why you have filed an early hearing application.
The petitioner is not
IA number
2. IA number 2 is the request urgency was there, so therefore we had to move that application.
Still, you have filed an application for early date. We are giving 310. We are fixing the date for finally. Then you withdraw this IA. You will withdraw this IA and will get appeal date. You will withdraw.
I withdraw that application. We are ready for documents today. The only permission is that
not withdraw.
We withdraw the
Mr. We are fixing the date. We are doing the application. You have to tomorrow. You want the portion we open on media and with the number we had the decision and pleasure of deciding a petition of 2008. I had standard very simple.
the only thing is that
I know 2020 and application on the petition spending relatively spending the sports since 2015. Therefore, I get one of 20 let the people by using some 310 I get 2015 and we considered at the time of hearing of the appeal. What is indeed, Mr. Who to take?
With two of the application with petitioners, the response after. So we did
No, no, no. These are doctors for engineers or chartered accountant. It doesn't make any difference.
this is not
See, whom do you want to appeal?
this is not an application. It's an application for the this is an application.
And there is some idea two of two yes, yes. So we they supposedly insisting they don't want to fight.
Yes, live
There is no
proceed
provision
plan
of but you are insisting. What happens to your insistence then if they don't want to fight?
But it is up to them, right? I bring you notice of the honorable.
See, Mister, he is not saying anything. Your which provision you file counter in a rate appeal? Please tell us, Mister.
Yes, sir.
We will fix it next week.
Yes.
You please tell us which provision, because we have been repeatedly asking this question to all the councils.
Yes.
So far, I have not got an answer. So we proceed on the assumption that there is no provision enabling a party to file counter in an appeal.
Yes. My lord, I have,
Because order of the learned single judge.
yeah, I have filed a vacate petition, my lord. Only, well, this matter has already been covered by this division. Very lodgement number 40. That is the case, my lord.
No, Mister, the interim stay is, Mr. Venkatesh, we will hear you of course, but interim stay is not to alienate, because the respondent number 4 has no jurisdiction to alienate the government land in favor of respondent number 5 and 6, presumably your clients,
Yes, madam.
because they are encroachers.
I'll not tell you, not to change is also there, my lord. What is sleeping happen unless I cover it, I can't do anything, my lord. Your lordship modified version, not to alienate, your lordship convert to not tell it, I'll not do anything.
But you will then alter the nature by constructing
No,
a multi-story building. What hours?
let me to cover it up, my lord. That's only this. Your lordship hear it next week also, it's only 1 week.
1 week?
Your lordship said 1 week, after 1 week, my lord, I'll make my submissions. Urgency was
This is vacating stay, Mister.
vacating.
We'll hear next week on vacating stay. 13th September, 13th.
Yes, we,
Mister,
yes, ma'am.
let the appeal be listed for consideration of IA number so and so on 13th of September 23.
Obliged.
Mr. Siddhartha Sharma requested next week, my lord, counsel for the petitioner.
Not well.
Not well.
What's your name?
Chakravarti.
Learned counsel submits that the arguing counsel is unwell. No, Mister, but he obtained a court slip yesterday in this case.
He's suffering with some conjunctivitis.
No, but yesterday he appeared and sought a mention memo. On this mention memo, yesterday he didn't realize that he would suffer from conjunctivitis, right?
Morning he called me and he
Learned,
asked me to-
it is submitted that he submitted praise for adjournment on the ground that the arguing counsel is unwell. List after 2 weeks.
obliged.
In this matter, I am appearing for petitioner. In this matter, senior counsel, Mr. Economic is appearing. He requested on next week.
Petition is admitted for hearing. Counter
Counter
if any
file,
on
yeah.
behalf of,
Counter file, my lord.
Counters file, counters and
I
replies.
completed. Yes.
Obliged.
May I please, Lordship. We have filed IA number 2 of 2023 restoration petition, Lordship. Seeking set aside the orders dated 16/8/2023, Lordship.
Set aside. Why?
The repetition was dismissed for non-prosecution, Lordship, which is neither willful nor wanton. We are held up with before the court number 9 of this honorable court, Lordship, while coming.
No, all of how many councils where you are there? You alone. We means who?
At that time, senior.
No, we means who? How many? We means more than one.
Lordship.
So senior counsel was held up in court hall 9
No,
and you were held up where?
AP High Court.
Court hall number 13,
AP High Court, Lordship.
AP High Court. And you and your senior only, nobody else.
May I please,
No,
Lordship?
no, we are asking you, madam. Who else is in your office apart from you and your senior?
One more junior is
One more. Where was he?
DRT, Lordship.
So you were in Andhra Pradesh High Court, junior was in DRT and senior was court hall 9.
My lord, this case merits are
Yes,
there, Lord.
madam, this is second round, it has been dismissed. First round also you didn't come, second round didn't come. That shows that you don't have any interest in prosecuting.
No, Lordship, which is neither willful nor wanton, Lordship. There are merits in this case, Lordship. The petitioner has
There's no- we are
complained
not
interim order passed by this honorable House.
Hold on. Hold on, IA 2 of 2023 for the reasons assigned in the affidavit, for the reasons assigned in the application duly supported by an affidavit order dated 16th August 2023 passed in WP 17276 bar 2023 is recalled in the result WP number so and so 17276 bar 23 is restored to file. IA is allowed.
Lordship, the petitioner has complained the interim order. Your Lordship may record the same.
Madam, you should study law instead of appearing before Andhra Pradesh High Court, right? Ask any senior counsel. There is a very good library, right? Just now it has been inaugurated. Mr. President has, with his efforts, go make use of that library. Find out the legal position and tell us at 4:45 in the evening when we are about to rise up that what is the position. When a writ petition is restored, what happens to the interim order? Read. Don't ask the court everything.
No, please.
May I please, your Lordship?
What incomplete petition you have.
This is petitioner pursuing the PG pathology, my lord, and subsequently she wrote the examination and she has
Oh,
allowed.
have you been admitted to the course in pursuance of the interim order which was passed on 30?
Already been participated in the counseling, my lord.
What happened? Got admission?
Not admission, my lord, and
So let them file counter then.
Lordships, tomorrow she needs to admit in the college, my lord, 8th respondent. I have filed IA number 2. And without insisting.
No, no, no. Have you? 90.
Yes, IA number 3, I have
Where is it, madam? IA number 3.
IA number.
Three. What is included, Mr.?
ESI college which allotted respondent, my lord,
You have to give notice to them, right?
yes. Page 18, my lord.
Page.
18 of IA number 3.
Ah.
The great respect.
Allotted
seat.
Sudhamala Rachna Varma. Allotted.
Yes, my lord. And your lordship kindly see 19th.
Arey, Mr. Has she been allotted a seat?
So that
You don't want to produce original document.
I need to produce, my lord, kindly maybe given time 15 days, my lord, and Honorable Supreme Court categorically directed in the writ petition on 21/10/2022, which is covered, my lord, without insisting the petitioner in admitting the PG, my lord, your lordship may kind permit 45 in repetition.
Last academic year, my lord, Lord, safety in pathology, my lord. So as per university regulation, my lord,
1 minute. His documents are with Kaloji University.
yes,
Then you will not return our documents and then say that I will not admit.
as per regulation, my lord, if candidate who is admitted to post, my lord, has
No, which university you are appealing?
Kaloji Naranda University, my lord.
The documents of the petitioner are with you.
The college,
Yes.
soon responded to my lord.
What is the interim relief list?
I request Court, my lord, in again to modify the orders by directing the 8th respondents to admit the petitioner without insisting the original certificate.
So then when will you produce? All right. Heard on IA number 3 of 2023. No, heard on IA number 2 of 23, issue notice to proposed respondent. Then heard on IA 3 of 2023. Learned counsel for the petitioner submits that in compliance of the interim order passed by a division bench of this court on 13/7/2023, the petitioner got herself registered for admission to PG course and on her own merit, the petitioner has been allotted a seat in which college?
In the 8th respondent college, my lord.
Which college?
Yeah, ESIC Medical College. Eighth
You will write ESIC, 8th respondent. It is further submitted that the original documents of the petitioner are with the university and
Not
the
with
last date of
So seventh respondent college, college.
are with the 7th respondent.
Yes, my lord. Earlier I
And
was
1
pursuing
minute,
there.
7th respondent and 7th respondent university and the last date of seeking admission to the course is tomorrow is what date? 6th of September
Yes,
23. It is therefore submitted that the respondent number 8 be directed to admit the petitioner without insisting for production of original certificate subject to petitioner's furnishing and undertaking that she shall produce the original documents within a period of 15 days. Paragraph. The aforesaid prayer has not been opposed by learned counsel for respondent university. Paragraph. In view of aforesaid submission and taking into account the fact that the petitioner has already been admitted to the course, to the PG course on her own merit, it is directed that respondent number 8 college.
yes,
Respondent number 8 college.
yes.
Respondent number 8 college shall admit the petitioner without insisting for production of original certificates. Needless to state that petitioner shall furnish an undertaking that she will produce the original documents within a period of 2 weeks. 2 weeks from today. Full stop. Accordingly, IA 3 of 23 is disposed of. Mark her presence also.
My lord, actually, my name is being wrongly reflected for respondent number 2.
Delete her name. Yes.
Notice will have to go to the medical counseling committee, my lords.
Notice to at this stage, after the order was dictated, so and so appears to video conferencing and submits that she has no instructions to appear for
Respondent number 2, my lords.
2. The office is therefore directed to delete her name from the cause title. Issue notice to respond number 2. Yes.
Right.
Certified copy today. 55.
I'm begged to represent Adesh Baba, my lords. This matter, my lords, Union of India has to file counter, my lords. The letter is not just filed.
Request file counter.
Mr. Praveen Kumar DSGI petition is admitted for hearing. Mr. Praveen Kumar DSGI press warrant is granted 6 weeks time for to file counter. pass over. Ah, that's why I'm saying pass over. I know that. Yes.
My lord, sir.
What is to be?
Lord, sir, these are the appeals, my lord, sir, filed.
This is what orders? What order?
Appear for the respondent report.
Ah, Mr.
My lord, the matter is coming up for admission, my lord. Four appeals, the matters require a
Hearing.
hearing, my lord.
Tell us some date in October, senior. Both of you subject to your. Yesterday the challenge with regard to validity of another validity of rules has been concluded. So we can't, I mean, students first, thereafter. The value will increase in the meanwhile by another 2 crores. Expect. So what is there? We said 25th is okay. 25th September.
Yes.
Right? Yes. Please, let the appeals be listed for hearing on 25th September 2020.
Let's say in the same caption as they're coming.
No. It will come. So don't, you can mention.
Yes.
25th September, give a synopsis, please.
Yes.
To cut short we can. So lengthy fact, as you are telling 94, 94. No, all those things have to be taken note of. We cannot simply say that
It's fine.
25th, see then 25th September. Yes. Next.
25th September.
Okay. What is
Which is
where was the letter? Where was the letter sent to or issuing the gazette dated 28/1/2020? Where was the letter sent? That is conclusive of it. If it was before 21, then that otherwise it has been subsequently made. Where did you send a letter to Hyderabad for issuing the gazette on 28/1/2020? Please,
Yes, your lordship.
if they are either unable to produce the document or produce the document newly fresh prepared, Mr. You should be very cautious. Yes. That time of facing we have
Advise them to produce the copy if it is available.
otherwise not.
Yes.
I the court has directed, therefore I will write today and on the back date on 25th January I will write a letter and produce it. Don't do it. No. We will send it to all the state council
Your lordship has to because the gazette, if your lordship, but
If you understand, did you get it what we told him?
yeah, property legal tools.
No.
Your lordship, but your lordship has stated
That he are asking when letter was sent to the director press issuing gazette notification.
Yeah.
I can understand. That is the such a letter is not, you know what are the conflicts. If it's when it has to be something to 28, and he has promised us that he will not match anything, ask them to
Yes.
manufacture documents.
In that case,
Because in that case, if it appears to be suspicious, they persons may lose their job. Because he will ask for, if he prepares today of 25th January 2022, whosoever Mr. Sanjeev Kumar, special government leader. The record produce difference is not discernible as to when and waiting is the list of this on 6th of September 20. Please argue. Yesterday also we told you were judgment in 19. So you argue will get corrected, which is your please. You are asking please for respondent.
Respond.
But he was seeking adjournment. Yes, all right. Yes.
Well, sir, I just passed on the connected case.
Addicted matter also you are the counsel.
No, I think
Who is the counsel?
not very sure. TCD.
You show madam. So that means this is like succeeding in the attempt to get an adjournment, right? So the counsel is there means what happens if we because the other counsel will obviously would not have to call madam. Madam, show his name in the list. Request that he which counsel. No. This one is still given. No. Show his name that he is required in protocol 1. What is this about, Mr.? Anything survives? Nothing.
Yes, very much survives. Not, it's a public interest litigation as it then was.
Public interest.
Yes.
99, it doesn't say PIN.
It doesn't say because at that point of time,
It was registered like that.
was registered like that. Not is against a conversion of a park to a private property. Not this writ petition was filed. And my lord, after the completion of pleadings, there was a district judge who was appointed to inquire into this particular fact. And my lord, after the district judge, my lord, gave an opinion.
All right, so this is a public interest litigation. Your grievance says that park has been converted into a residential complex.
Yes, a commercial complex. The first round of litigation. In the first round of litigation, my lord, this court held. The defense was that the private.
What is the other petition about?
Same issue, my lord. Same regard to, I believe it is with regard to conversion of the park into a commercial structure.
So that council can adopt your submissions, right? And the respondents are same.
Yes.
Represented by same council.
I'm not very sure.
This my lord.
You should. Who's? Yes.
Yes, my lord, here the defense of the private respondents was that, my lord, this property was converted into a commercial space by housing board. My lord, this land was acquired, my lord, by the government, my lord, for purpose of Indian Airlines employees. And my lord, UDA had approved, Urban Development Authority, my lord, approved the layout. And my lord, handed over to housing board for construction. My lord, their defense of the private respondents is that the housing board, my lord, has altered the plan, converted this park into a housing plot. And there in those housing plots, my lord, these commercial structures had come up.
Bangalore Medical Trust is still a good law. Bangalore Medical Trust. AIR 91 Supreme Court 902. So please, Mr. give us some facts, or we wanted to have a look at some of the facts. What happened? Brief note. AP Housing Board country. This is note.
That's the chronology of.
Yes, that's what, because we have to write facts. So
That's the facts. There's no dispute to this fact.
that is 90. Where is that ALD judgment and Supreme Court remand order?
That is in the
Sort of question.
page number 1.
And including our Delhi, Noida. Suppose we are the other side.
Right. I agree.
This is an order passed on consent of the parties by Supreme Court. That is very order set aside matter be remitted. Therefore, it is remitted.
Yes.
2001 madam, whatever, ALD 533.
Very just.
And what happens to the other, this thing? Please send a message for which advocate, whatever. Get him here. Get him. No, apart from that, get ask, hey, Mr. Praveen, you know there's some advocate by this name.
Yes, shifted practice to Andhra Pradesh.
Yeah.
That is shifted practice to Amaravati nowadays.
So this is again a public interest litigation, right?
It's also a public interest litigation.
Huh?
I believe so.
Get the order, get the petition, madam. Yes, shifted to. Then what happens? See, supposing if we, if we decide your petition, his petition would follow.
Consequence. Because both are residents of that particular colony and both have espoused the cause.
Same order, same order. This very petition to sort. Yes, Mr.
All those issues, not the stand of the official respondents, not MCH, the APHP, and not FUDA, not is that the land is earmarked as and the defense lot of the unofficial respondents that it was subsequently converted by the AP Housing Board into a
Please, first of all, you tell us your submission, then you can elaborate. What is first submission?
the first submission is land is earmarked for lot. And this is a admitted fact. Not as the originally when they put on the layout, this land was earmarked for farm. The defense is of the unofficial respondents.
What is the submission? It is earmarked for the park, therefore no commercial complex.
No commercial complex will not come up there. Unless Buddha alters the layout. It's only the Buddha melody which can alter the layout. But as an interpolation, there is a tampering of the original master plan. Original there the APA. An interpolation. It is not a visual layout. Now,
visual layout prepared by
their counters may not file in Supreme Court. These facts may not have been explicitly elaborated. Therefore, may not the APHB says it's a park. It was never converted into a commercial complex. MCH says may not it is a park. It has never been converted to a. Buddha says may not it is a park. They have never converted it. So all the three official respondents. Speak in support of the fact.
No, that's correct. All official respondents say that it's a park. Then how come a commercial complex comes?
But the commercial complex comes because of tampering of the original plan by the housing board. Some of members may not have housing board. There, that's what their defense is. The stand of the housing board is that there has been an interpolation.
Which paragraph? What like? Counter which paragraph? That it has been tempered and all that. It's a park. Please give us paragraph numbers.
But, page 42, not of the 2007 MP, which were filed. I have referred it in my brief note also.
Mr. Bhagar is appearing in one case? No.
Office attached not to.
We will deal with that matter as and when it comes. The same issue, right? Same, we got the fight. Please see, Mr. Is it same issue has been raised?
In fact, earlier round, both the petitions were considered not common order was passed in 2001 680.
Sorry for the interruption. The TCD Shaker was my erstwhile colleague. He is now he's shifted his practice to Andhra. He is now a government feeder there.
This is a PIN, right?
And but he has handed over files to another colleague of mine who is now suffering with conjunctivitis. He will be back, I think, by Friday or Monday because he's back. highly affected with conjunctivitis. I am also not able to get his assistance in my office. He has handed over all the files to another colleague of mine, who is now suffering with conjunctivitis.
Perhaps I had appeared as a counsel for the housing board then.
No, Mr. Our only anxiety was that it is pending since 99. Therefore, we decided we wanted to hear, but all the attempts are being made to seek an adjournment ever since we have started.
Please consider having it on Monday, Milord. My other colleague may represent.
I would also
You tell your colleague that if he doesn't turn up, we are not dependent on him.
No. I know
We are not dependent on him for his assistance. We will decide it.
please,
It's a public interest litigation.
Yes, please have it on Monday, Milord.
He cannot have any lien over public interest litigation and argue as per his convenience.
No, please have it on, because he's suffering from conjunctivitis that I know. I think your lordship may kindly
I
consider.
to be able to assist, not because in
12th September.
after being
Complete.
This, 12th September, please continue.
12 September.
Arey, Mr. Please understand this, supposing we are ready to decide it. But again, on a technical ground, you will lose out. Again, it will appear in that connected writ petition, conjunctivitis, Andhra people and suffering. He will say no. Do you realize, Mr. Counsel?
I understand.
What the builder will say, the person who has constructed commercial complex, connected writ petition was filed, common order was passed by a division bench, the yet later division bench not listed. I informed the court that it is this thing. Then senior counsel said that conjunctivitis. Despite that, court did not proceeded to hear the matter and decided by rendering thereby my right to be heard. We don't want this to be given to them. And we will make it clear. Please tell him that, that if he doesn't appear on Tuesday, or still continues, it's a public interest litigation. We are not dependent on him.
Yes.
For assistance, we will assist ourselves.
Please consider.
No, it is being adjourned only because it may not have been adjourned. It is being adjourned with a heavy 99 petitions are pending. You people are citing adjournment. Yes, not fair. Not fair. This petition, not fair. This petition, then I also don't know, Mr. 12th September. No, 12th September.
No, requisition 2573 of 97 will be posted along with this.
That's why conjunctivitis with the council is suffering from conjunctivitis.
My learned friend is saying some other restriction, not three.
No. This can't be go on. Some other petition number you will give on. Have you filed an application? Then file an application. This is oral submission, cannot be entertained.
Then you should be permitted to see the record belonging to the registry. I'll update my file.
Anybody can inspect the record for that. I don't think any court's permission is required.
letter to the registrar is
Registrar, no?
a letter to the registrar is required. That's enough. He permits.
Registrar permit.
Letter to the registrar, he permits. That will be done in the presence of the concerned SO.
Mark the presence.
Note I
This public, mark the presence, this public interest litigation was filed in the year 1999 with a grievance that respondents September, please. If you're not there, you can make some arrangement. And
I
we
have
can-
with on the legacy case. I have.
Nothing. Yes, madam.
And the response number 1 and 2. What is it not, it's like challenging the registration of the
Anything survives, madam?
housing society to which was aid COVID society.
You are respondent of petitioner.
I'm the respondent 1 and 2. Madam.
Yes, so IT registration of society is not applicable under the state credit petition list. Society Act. Society Act. That's the- She doesn't know. Ask her whether applicable. According to the city list,
I don't have any instructions. Not kindly taken up on Monday. Below.
I think
I mean,
nobody sit down, madam. It will not be adjourned. These cases are not listed for seeking an adjournment. No instruction, then get out. Don't appear. No instruction means don't appear. Sit down.
I'm sorry, but
Sit down, madam. If you don't have instructions to argue, sit down. That's what counsel said, senior counsel. I don't have instructions. Because you say that you appear to assist this, but very often you create obstruction in decision cases. And just that body movement would be the this thing. It should see no cases. It must be something must be it can't be like this. It can't be under Article 226 registration. You can't hear you speaking adjournment. You want to argue there will we will hear you otherwise. No, we will be available copy today. Go to Delhi. Yes. If he decided to, right now we don't know. Because she is also not telling us. You sit down, madam. If you don't have instruction, please sit down. Please sit down. Please speak yourself. Now.
Will say about
No power. Is the all we know that now we will be hearing that medical admission budget it will not come. Therefore, keep this alive as long as possible. We think and to be on bill basis every day in
Yes, for me,
your job is work. I will still I have done your job. You tell that it is not good to decide coverage that you are seeking treatment. You sit down. And for parties. In this writ petition filed under Article 226 of the Constitution of India. What senior counsel you constantly stare at me? What is the matter? It's not your case. You know, you stare constantly, so my mind goes there. If somebody is staring you constantly, then
nothing in that. I'm just following the procedures.
so like it's not your case, right?
No, I can follow any case, but I'm going
No, of course, no, but constantly you stare.
to follow the case.
Outside, yeah. You can follow any case. This is an open proceeding. This thing also attend on anybody can attend online also. But I only requested that you constantly stare, so I slightly uncomfortable. So I shared my this thing. Yes, you can watch.
So that is the all websites are looking at.
No, no, please do not constant because my mind get because you constantly if somebody's you will understand. If I constantly stare at you, you will get it. Yes. The petitioner inter alia has challenged the order of registration of the Bharani Mutually Aided Cooperative Housing Society Limited passed under Section 8 of the passed under Section 6 of the Karnataka of the Telangana Cooperative Societies Act 1964. Full stop. Has an alternative remedy of filing an appeal against the order included in this petition, which has been passed under Section 6 of the Telangana Cooperative Societies Act 1964. Full stop. The petition has been pending before this court since 1999. Therefore, it is directed that in case petitioner files an appeal within a period of 2 months from the 2 months from the date of filing or 2 months from today, the appeal, the benefit of the principal incorporated under Section 14 of the Limitation Act 1963 shall be extended to the petitioner, and the appeal filed by him shall be dealt with in accordance with law. According with the aforesaid liberty, the petition is disposed of. Next. Let's see. See, there is absolutely no justification for dealing with this. It will not today be a take it up. Tomorrow, why? Yes. Yeah. Yes, please.
Let's the matter come up a little earlier. This honorable court, my lord, direct. It's the regime, my lord, under which orders were passed and the matter was challenged, my lord, before this honorable court doesn't exist any longer. Right? New, my lord, rules have come up. New rules, my lord, are enforced.
So what?
Therefore, my lord, this honorable court directed to your lordship's level look at the order dated 16.
So they are not done it, so therefore it has to be done.
No, it's there.
No, can you tell us the facts? Because we questioning is you are give us time so that we go through.
I'll briefly narrate facts. WP number 15374 of 97.
Where is the order, madam? Passed by learned senior. Where is this? Memo of appeal 2055. Date of it and order passed by learned senior. Where is that? 19th April 20. This is an order. Where is the memo of appeal and this will legally to because we will get it.
I just give lots of facts. That's how we interpret it to public. But they were failed. And then what happened. And what's the change in the reality?
That will be fine. This is complete. Yes. In cases we keep our complete work published by 98 or book and very active of but it's incomplete. We want to know what is the dispute, what are the what is the appeal about. We don't know anything about, so we are trying to find out.
Give the facts for I'll read the facts.
Your experience in a council 4 sentences you put that in over. When you say narrate,
I was not allowed to begin, Manoj.
No.
I was not allowed to begin. Your lordships are looking into the papers. But I will do that, Manoj, in about 5 minutes' time.
Please go ahead. It's your case. We are
WP number 15374 of 97 was filed by the builder, appellant before your lordships. That's the main judgment. That's the main writ petition, which the judgment is rendered. When it comes, collector writ appeal, Manoj, is
filed by builder for what?
Manoj, challenging the order of the government in asking him to moderate a certain amount as penalization charges. For constructing moderate 3 floors over and above the sanctioned. Moderate as against that moderate writ appeal number 2072 of 2002.
No, filed by builder
challenging a memo issued by the government.
What is the memo?
Moderate asking the builder to pay.
Dated, etc. Not
Moderate
there.
memo, I'll just give you lots the date. Moderate. It is the I just give lots to the. As against that moderate, that
No, memo issued by state government doing what?
moderate direct the petitioner appellant to pay certain amount as payment.
Directing the builder
Builder
to pay
certain amount moderate as penalization charges. Calculating moderate the FS height floor space index at 1.1:1.
penalization charges.
Moderate calculating the penalization.
What is the amount?
Moderate the
It wouldn't it have been better if you had given us a synopsis sort of. We are required to write every charges calculating.
Calculating moderate the FSI floor space index, which was prevalent at that point of time. At 1:1.5.
So in respect of 3 floors constructed without sanction.
Without sanction. While 3 floors were permitted, but he was asked to pay this penalization charge.
Without sanction, right?
No, they were not sanctioned, but with the penalization charges.
Yes.
WP number 2055 of 2000.
You prepare a synopsis, Mr. This can't go on like this.
Right.
We will have to write 15 pages and we are not stenographers also. So, wish we could have done shorthand this thing. No, part of the job means Mr. Senior Counsel, times have changed. Right? The court is under tremendous pressure, and as an officer of the court, you have the duty to assist the court. So this all we should be done by youngsters sitting comfortably.
That may not be necessary because there is now a complete change of legal regime. Which have an amendment to the MCH Act.
So then what? There is a legal change. Then what? You are not saying beyond that.
Because of the division bench directed the MCH to submit a report as to
what? So what? That interim order you have pointed out. Thereafter what?
Thereafter,
they are done so.
Final orders will have to be passed by this honorable court based on the report.
The report is in your favor.
The report, is partly in my favor, partly against me. What is an application for regularization to which I am entitled to make?
So nobody appears to oppose you, right? For GHM.
Match has been compromised insofar as the flat owners are concerned. May I suggest one thing, the MCH has submitted a report. MCH have the final say in the matter.
Hyderabad, Greater Hyderabad.
Lords, I am appearing for GHMC, Milord.
What do you say? He says that in terms of report it be disposed of. What do you say?
Yes, Milord, we submitted a report before this honorable court as the entire law has been changed. Now the left open for him to apply under.
No, he says that in terms of the report submitted by you,
Let the MCH pass a final order.
final order.
Yes, my lord.
And my lord,
Within how much time you will file? Pass final order. 4 weeks he will file. Correct.
Let them pass final order, my lord. If they pass any order against me, I have a right of appeal. I will use that.
So this can be disposed
This can be closed.
Mark the presence. This intra-court appeal has been filed. These intra-court appeals have been filed against common order dated 15th day of November 2002, passed 15th November 2002, passed by learned single judge in WP number 14807 of 1990, WP number 15374 of 1997 and WP number 11648 of 1999, by which the writ petition has been, what has been done by single judge?
The third dispense my writ petition.
By which writ petition preferred by the appellant seeking to,
And allow the writ petition by the platform.
by which the learned single judge has dismissed the writ petition preferred by the appellant stroke builder and has allowed the writ petition preferred by flat owners. Paragraph.
Association, your lordship, I appear for the association.
Paragraph. Thank you for waking up now. The order
Lordship,
will be-
because your lordship said
Yes.
that
The-
matter is being disposed of. There's a compromise petition filed by me in item 60, your lordship, because my writ petition, if that is ordered, I have no issue for whatever orders.
And under the builder, they had a grievance with respect to parking space. And that's been agreed to, and various other aspects have been agreed by the builder.
When paragraph. No, we are disposing of his writ appeal. Your matter will be called.
It is a batch, your lordship.
So except 60, we will pass. Yours appearing in 60, right?
Pursuant to when this compromise petition was
58,
filed.
59, 60, 61. These order which we have been dictating, right? Your case will be heard later, little later. So, learned senior counsel for the petitioner submits that in compliance of an interim order dated 16/2/2020-22 passed in writ appeals, the commissioner of GHMC has submitted a report commissioner within such time limit as may be directed by this paragraph. We have considered the submissions made on both sides by this paragraph. We have considered the submissions made on both sides. The relevant extract of the report. No, report is what? Where is the report? What is the operative portion? What is the, can you please tell us what is the report operative portion where what does it say? The direction in this thing, PIL. The report is what? No, this continuous effort move as per orders as submitted representation expected. Your application seeking regularization is pending.
Let them pass off.
We have considered these submissions made, but you are unable to tell us what is the report, right?
Full
Full stop. The again, we request senior counsel. Consider the submission and peruse the report. In the report, it has been stated that sanction plans were issued to the builder in respect of ER number. In respect of PR number so and so, right?
Item 60, your lordship, compromise IA may be ordered. Item 60 of the batch, compromise IA may be ordered.
Oh, but she's saying something else.
One of the association, I want to read our.
Sit down.
They will also be heard.
IA may be ordered, and anyhow, because I'm not in the other writ appeals also, only as far as 60 is concerned, the appeal may be disposed of in terms of the compromise arrived between the parties.
Compromise arrived at compromise.
Item 60.
Yes. This appeal rises from an order when the parties submit the dispute between the parties by inviting council to participate by inviting IA 6 of 2021. That is a compromise petition which has been signed by the parties as well as their council. No, Mr. They have given in process of military order after 16 to 2022. Right? What is the department? They will better submitted the representation. He is have been disposed of that. No, Mr. In case you wanted open data and is not opening, it is to be ready. We don't know what is how in this Mr. Whatever is the representation, it's not we said that GMC will decide now between two parties. GMC will also be heard. Yes, and this in period, this is my education unit. So in case you are already always put in from area providing parking given the no, and the end doesn't come to them.
I have point out before the SH connection who is the backfiring authority.
No, but you say that you are bound by the concession, right? At least we can record. Which is when it is given. When it was given, please tell us. When it was given.
Same order.
Same order. Same order. Achha, all right. 16 to 2022. Yes, madam. Right. His submission. Learned in the beginning, no. Beginning of his submissions, learned senior counsel for the builder clearly submitted that the builder is bound by the concession given by the builder before this court with regard to parking area as recorded in the order dated 16 to 2022. Right? Yes. Now this the appeal is somewhere in now. What is the life of entry point?
Yes, sir, but it is a simple direction.
The simple direction means in his appeal, simple direction. File a petition, mister. How this thing, if somebody else's case, you will intervene like Article 370 matter is going on in Supreme Court. You will file implicit petition and say that my plot be registered, say deed be registered, simple direction. You have an independent cause of action. How can you agitate that cause of action by impediment?
Only please that it falls within the permitted.
No independent relief can be granted to you. Why is that it will dispose of? No impediment. There is no impediment.
Yes, but what 2019?
Yes.
Yes, it be number 2016.
Compromise. So we will say that number 2 of compromise. There you write that number 2 of and KNC implement is disposed of with liberty to be in teacher seeking implement in prosecute their own, prosecute the remedies which are available to them. Do it. Yes. Yes, please.
The short point, which arises for consideration,
Short point.
except becomes challenging the wires of the statute, my lords.
What provision?
Section 5A3 of the Textile Committee Act 1963.
Section
5 capital A subsection 3 of the Textile Committee Act.
Section 5A 3.
3, my lords.
3. Number 3.
Number 3 of Textile Committee Act 1963.
Huh?
Textile Committee. Textile Committee.
Textile.
Textile.
T.
T.
Textile.
Committee.
Act
1963, my lords.
1963.
Yes, my lords. The lordship.
What is it?
So I'm seeking for a short accommodation, my lords.
No accommodation. There is no accommodation here available. You need to see.
So I'll undertake, my lords, on Monday. I will.
No, sorry. Sorry. Except for adjournment, you say everything. We thought that you are trying to tell us the matter on merits, but forget about it. Forget about adjournment. Tell us whatever you can.
Yes, the provision, my lords, is extracted at para number 3 of my
Textile Committee Act. What happened? Notices were issued to you 17.5 and 27.2.
Yes.
What happened?
2 notices were issued, my lords. A demand was raised, my lords.
Who are you, Mr.? Tell us the facts. You are self-mins, right?
Yes, my lords. I am the studying, my lords. I am into the business of, my lords, processing of textile.
I am the managing director of the company. Challenging notice under it. Yes. Madam, Rules Act. Textile Committee Act 1963. No other High Court has examined the validity of this provision. You are the first one after 1963, right? No, we are asking.
To be honest, my lords, I couldn't.
You don't know, you need time to be honest.
Yes, my lords.
No, forget what. This is our job. We have taken out to do justice, we will have to do justice. You will only seek adjournment, Mr. Nothing else.
I undertake to.
No, nothing. Sorry. We want to give message to the bar that these all old matters are not listed for adjournment. Monday, Tuesday, undertaking. Nothing. Rahul.
The relevant provision is extracted at para 3 of my affidavit, my lords.
Yes. 3. Duty of excise.
Yes. There shall be levied and collected as an imposition of cess on cess for the purpose of this act a duty textiles and textile of excise and all textile machinery manufactured in India at manufacture India such rate not exceeding 1% ad valorem as central government may be notification of official gazette fix. There's a proviso, my lords. The duty of what is relevant, my lords, is clause 4, my lords. The manufacturer shall pay to the committee the amount of duty.
You are challenging clause 3.
Yes, madam.
You have just now told us that you are challenging clause 3 or clause 4.
Clause 4 is on merits and clause 3, my lord. Yes.
You have challenged the validity of which provision? First tell us. 5A3.
5A3, my lords. The duty.
5A3.
Yes, my lords.
Shall be collected by the committee in accordance with the rules from every manufacturer of textile so and so in this 5 and D referred to as manufacturer.
Manufacturer.
What is wrong with this clause? So Parliament has no power to enact this law. What is it?
At para 10 of my affidavit, my lords, I have given the reason, my lords.
section, find out validity of section 5A, 5 capital A within bracket number 3 of Textile Committee Act 1963, whether it has been upheld or examined by any court, Supreme Court, everything. Right? 5A number 3. 5A3 of Textile 1963. 5 minutes. Let's see what really pen will happen to be not challenging the living exercise duty. Right. This provision is not challenged. This only says it shall be collected by the committee in accordance with the rules from every manufacturer. I don't need to see the processing. They are not a manufacturer. That is a matter to be contested by them. Since I maybe can be only textile which is manufactured by this petition. There will be steel. Such maybe it is not a manufacturer, then that is a thing to be established in facts. Yes. Mister, your grievance says that you are not a manufacturer. Therefore, levy cannot be recovered
Yes.
from you.
On merit.
Then, Mister, then this is a fact which you should establish before the authority. The provision does not become bad, right?
Right.
You see, Mister, another thing is what it appears to us is that you are not challenging the levy of cess. Rule 5A3, section 5A3 only provides for recovery of the amount by the committee in the manner prescribed under the rules number 1 from and secondly from the manufacturer of textile machinery.
Yes,
correct?
Yes.
So you are saying that I am not a manufacturer.
I'm only a
So
processor.
if you are not a manufacturer, you establish this fact in response to the notice issued to you. The authority will satisfy it. We will say that Mr. Listen to us. We will say that you can, in response to the notice, you can contend that you are not a manufacturer. the court will, the authority will examine your contention and then proceed to recover. Is there any stay in these petitions?
Yes, there is a stay in the as per.
Stay? When? Oh, interim order has prayed for. Must be, can't be like this. Why? It is 7. 5A. 5A. No, but this will survive. Because it is for a period. See. This act has, this provision has been repealed with effect from 2016, Mr. But the dispute survives because it pertains to a period prior to it.
1997.
So then you, Mr. You go and tell the authority that I am not a manufacturer, this amount can't be recovered. But the provision, how is it, this thing? See, you can challenge the validity of provision on what ground? And provision of a contained in the act that the legislature enacting it had no power to do so. Secondly, it is in violation of fundamental rights. What is, these are the grounds of challenge. What is, I mean, you, it's not your case that parliament doesn't have power to enact the law, right? Then what is violation of this thing, fundamental rights, article 14? Nothing. It, section 5A3 provides for that the cess shall be recovered by the committee in the manner prescribed under the rules from the manufacturer. So levy of cess you are not challenging. You are only challenging, there is nothing wrong. It's not that dehors the rule, it may be recovered. Nothing, it in accordance with the rules recovered. Nothing wrong.
From 10 is
No, Mr. We understand your grievance is that you are a manufacturer. But it,
in 11, yes, Mr. Sai.
so therefore, no. So therefore, this fact has to be established by you before the authority which has issued you the notice. We will direct that the interim order will continue till you file objections to the notice and demonstrate before the committee that you are not a manufacturer, therefore not liable to pay the amount. And we are upholding the validity of the provision saying that it doesn't suffer from any infirmity. Correct? March 97 to March. Notice dated. Dated 17/5. 22, 2002 to and 17/2, 2002 to petitioner number 1 and remaining 2 to 4. Yes. If any problem, please ask. Because I will not remember what I have dictated. You ask if any problem. Who are you, Mr.? No. What have they described themselves? Who are you?
Yes, I am the, I'm appearing for all the petitioner millets. I'm the spinning mills millets. I process the textile.
Where have you said in your affidavit?
Millets. If your lordship sees millets.
Which para?
Yes, millets. I'm coming to that.
Para?
If your lordship sees para 6 millets.
Para 6.
Each of the second line, each of the petitioners are engaged only in the procuring grey fabric manufactured by power looms.
No, para 6 is not this thing.
Your lordship may see page 10, my lords, page 10 of the affidavits. Page 10, bottom, my lords.
There is no page 10. Ah, yes, yes.
If your lordship sees, my lords.
Para
number 6, my lords.
6.
Second line, each of the petitioners are engaged only in procuring grey fabric manufactured by power looms. The petitioners are only processors.
The petitioners, your companies, right?
Yes, my lords.
Yes. The petitioners are companies registered under the the companies registered under the provisions of Companies Act 1956. The petitioners claim that companies are registered under so and so, comma, which and claim to be engaged in the work of processing of fabric. The petitioners claim that they neither have any spinning nor weaving unit or any machines for spinning and weaving. Full stop. The petitioners in this petition have assailed the validity of section 5 capital A within bracket number 3 of the Textile Committee Act 1963, herein after referred to as 1963 Act. Paragraph. The Parliament has enacted the 1963 Act, which provides for constitution of a textile committee under section 3 of the Act. The functions of the committee are enumerated under section 4, whereas section 5 of the Act empowers the committee to impose cess for the purpose of textile and of textile machinery manufactured in India. Full stop. Section 5A of the Act
I'm only concerned with this only one writ petition.
Madam, get other petitions also. What are the orders passed in these petitions? Find out and get it listed tomorrow. Yes. Next. What is it, madam?
I appear in item 66 and item 7.
Yes.
2 items. I appear in sum and substance.
Bunch, same.
No. My cases are slightly different. But in my case, the short question is, look, these are all ex-servicemen. They were.
No, we want to only know.
I just indicate.
No, 1 minute, please. All the cases issue involved is different, or your case is different?
My cases are different according to.
All right. Which case item?
66 and 70.
66 and 70.
I'll just indicate.
1 minute. So we will hear other councils.
No,
we will hear you, of course, in 66 and 70 separately, but 65 and other batch, whatever up to, madam, 90.
And they were asked to file counters, no counter is.
Fine. They don't want to file counter. Yes. After 19 years, we don't think there is any possibility of granting them.
Just give me 1 more minute, Lord. In my cases, which are item.
We will hear you separately.
One second, but please let me complete. An Atkins writ petition was allowed against which an intra-court appeal is also filed. That is not there before this court today. Similar matters like 66 and 70, another writ petition was allowed by a learned single judge of this court, against which they carried the matter in an intra-court appeal. That intra-court appeal is pending.
You are appearing in that intra.
I am appearing in that. I myself.
We will get the order. We get the record. You are the counsel. You know everything.
Very well.
We'll get it. We will hear you, senior counsel. It can't happen that without hearing you, the order will be passed.
I'm sure, my lord, the court would hear.
Yes. So we are others. We will hear and then we proceed.
Item 75. Item 75.
65. What is there? 65 and Mr. So do we take it, madam, that except 66 and 70?
Yes.
In all other matters up to 95, the cases are similar?
Well, not all the matters are similar.
He is saying different.
Very well, my lord.
We will hear him 66 and 70 and give that rate appeal, please, number. Madam, call the record and list it.
The second number, my lord.
1 minute, rate appeal.
Writ appeal.
Please give senior counsel.
Second number, 1, 2.
Rate appeal number.
Writ appeal number.
My lord, writ appeal number 1232 of 2008, which is showing as.
Number. WP number 19097 2006 में तो writ appeal है, sir. I'll give the writ appeal number.
Please give.
I have the writ petition number 1909.
No, how do we find out the writ?
No, I'll give it, Lord.
Please give.
Right.
So in the meanwhile, you find out and we hear the others.
Very.
So all other cases point is similar. Yes. Who argues for petitioners?
My lord, item number 2 in the list of the writ petitions, my lord, there is a writ appeal.
No, there is no item number 2, madam. This is 65. Item 65.
Yes, my lord. In which starts at 65, my lord. There is a writ appeal number 1232, my lord, of 2008.
Which is 71.
That is serial number 71.
So
this has been preferred against the order of the single judge, my lord, which the senior counsel.
Probably senior counsel is referring to this other senior.
Another senior counsel is appearing, my lord. On the last occasion, the senior the colleague is here.
Your lordship, and for respondent number 5 in item 71, your lordship.
No, madam, this is not for adjournment, right? Fine.
No,
Here very well. No.
As per my
Please do not.
instructions, your lordship.
You want to withdraw? You are respondent, you cannot withdraw the appeal. Yes.
Your lordship.
Yes.
Lord, item 71.
Forget about adjournment.
It's a writ appeal.
No, if you want to argue anything, please go ahead. Otherwise, we will see what is the matter and decide. Don't want to argue. Item number 65, madam, give what is 65. First case 3162. Three one six. So, madam, you need to tell us, right? So all matters except 66 and 77.
Yes, madam.
70. In all the writ petition, petitioners are seeking a direction to hand over possession of some land.
Yes, your lordships.
Right.
Assignment land. Yes.
Huh?
Yes, my lord.
Assigned land.
They are seeking for allotment of land, my lord. All
Not allotment, madam. Declaring action depriving petitioner of property to the extent of 5 acres of survey number so and so, illegal, arbitrary, without jurisdiction, and direct to forthwith hand over possession of land. If the alternative to allot alternate land of 4.20 acres, some village. This is the prayer.
Yes, my lord. I'm passing on a short note, my lord.
So first is prayer is to hand over possession of the land.
Yes, your lord.
Second is alternative relief of allotment of some land.
I'll draw your lordship's attention to this.
65, item 65. What is the issue involved in this matters, madams, in these matters, madam?
My lord, in all the matters, what is the issue involved is, my lord, there is an extent of land which is not a revenue village, my lord, that is called as Jawahar Nagar. And this is the land,
madam, this is WP 321232.
This is the writ appeal, my lord, against lot of writ petitions, my lord, similar issue. This writ appeal was to take the lead, my lord. The subject in short
madam,
is, my lord.
1232. No, so writ petition, how they have been linked?
My lord, this writ appeal, your lordship may kindly take up, my lord.
So if we decide WP 12, everything else will be decided.
Most of the writ petitions are following, my lord, or against a single judge's order.
Other two, except two.
Yes, my lord, except few.
Give madam two. Missing WP 1232. Writ appeal. Number one. No. Ex-servicemen, so they are entitled to allotment of land under some scheme of the government, and they must have been allotted.
Lord, I beg to represent Mr. Ashwini Kumar, my lord, counsel for the appellants in this matter.
Yeah.
IT petitioners, such a they are giving right, not compensation. Because with the land of which they are in. It's very true, 50 is 50 is in the understand petitioning was showing. This usually relates to very things. I think mistake they don't see. Still problem. Still problem. So if not 15 depends. They were into 5-4 parts. But he has given two options. He has given two options. He has given money, which will save time. No, he has only said comment. Leave of sign. See, page 39. Page 39. 39. My copy, I don't know. In terms of page 29. He gives two options. He said two options. Page 34. Internal page 20. Second option appears to be more at a wanted. Better. So, there is one for second option. So this was it's very neat 2008. But it was it's a very big you need to see. This is it's the responsibility. You have filed this appeal?
Yes.
1 minute. They, but you are saying Tehsildar is saying appeal. Set aside the orders and dismiss the writ appeal.
That is for the vacate.
1 minute. Huh? But you handed over to us saying that I am giving written synopsis. So we were wondering that how can respondent who has accepted the order passed by Laurent Single Judge say that the order be set aside. You are not at, that's why we asked who has filed the appeal. No, that's correct. But you have accepted the order, correct? You have not filed an appeal. Huh? Which appeal? Madam, then you should argue your appeal instead of this thing, some appeal in some respondent.
Not against this order.
Huh?
Not against this order. No appeal is filed against this order by the government.
No appeal.
It is in one of my matters, my lord, which I succeeded before the learned single judge. The state is an appeal in WA 3737 of 18. And I have a copy of the learned judge's order.
737 of
2018.
Madam, get that WA 737. We will hear senior counsel.
And I have the order copy of the learned judge.
Yes. Madam, what appeal? Which appeal have you filed in this bunch? Not listed. His appeal.
It's not listed today.
It's being called because senior counsel is there, no? He knows. So you argue that appeal. Where? Get 737. So what you have to say, Mr.
Lord, my writ petition was filed questioning an order of joint collector, my lord, which confirmed the order of RDO, rejecting.
No, you are appearing in 1232.
1232 for the appellants, my lord.
Appellants, you are appearing.
Yes.
Why is the learned single judge held that you are entitled to
yes, for
this
28
thing? 1 minute. Assignment of land instead of saying that since it has not been allotted and whatever you are continuing in unauthorized occupation of land on the basis of a allotment of the society which had no authority to allot the government land, right? So learned single judge has directed that 15 lakhs compensation should be paid to you, right? So what ground you are challenging the order now, which is seemingly in your favor? You want that the allotment patta should be given in respect of land in your possession and you will convert it into commercial complex and sell it after 10 years at the rate of whatever.
Already, even in 2011, my lord, this question fell.
A lighter weight, Mr. We are not, we will hear you. We are asking what are the grounds of challenge to this order? WA 1232, please, one by one.
Learned single judge, my lord, having held in my favor that reject, my lord, learned single judge.
So it's only confined, right? So the learned single judge should have directed allotment of land in your occupation. What else?
My lord, I'm sorry, my lord, under the PSOs, my lord, under the PSOs board standing orders, my lord, ex-servicemen, my lord, in anticipation of an assignment, my lord, possession can be handed over, my lord. Therefore, possession part is not illegal.
No, you should thank yourself that the government has not chosen to challenge that order passed in your case, right?
They've been fighting for this from 1974. They've been fighting for this land for 1974.
No, but you are continuing in occupation, right? Reaping the benefit, doing agriculture, selling the crop every year. Are you not? This is your case that you are in cultivating possession, carrying on agricultural activities. What fighting?
For assignment.
Mr. You have fought for the country, forget about it now, right? So first submission is that single judge ought to have directed allotment of land in occupation of appellants, right? What else?
Having agreed with all the contentions raised by the petitioners, ought not to have rejected it. The question,
rejected, not rejected.
This entire land was given for assignment towards ex-servicemen, the lapse on which, whatever lapses that had happened in terms of assignment.
Mr. If we may ask you, what authority cooperative society had at that time when it made allotment in your favor? If you can tell us.
Just minutes with the interruption. Minutes, IPS for Justice.
We will hear you. He is now arguing. Nobody stood up, right? That's the problem. He alone stood up. He is arguing. So we are asking him. So, Mr. First, tell us submissions, right? So one and only submission is that single judge ought to have granted. That we have understood. Ought to have this thing directed allotment of land in your favor.
Only ground on which I was rejected, my case was rejected is that the land now falls in urban agglomeration, the prices have shot up.
That is irrelevant. You can carry on agricultural activity and everybody else will be, neighbors will be benefited. They will get fresh air.
But even as on
You
today,
will not use pesticide, bio, organic culture.
as on today, Molot, there's still mango orchard, Molot, all these affidavits have been filed into court along with photographs. It's way back in 2011. It's
No, so Mr. This again you are slipping to the facts. Affidavit, mango, tree and all this. What we are saying, legal submissions. Only one submission, right?
Yes.
That's it.
Having held that, having held all the grounds.
Yes.
On
Having held in favor of the appellants.
and rejecting all the 5 grounds raised in the impugned order, Molot, ought not to have directed compensation.
Directed assignment of land.
But now after all these years, Molot, 2008, 3 lakh.
What happened? There is no 3 lakh, 15 lakhs lump sum compensation.
3 lakh.
We were wondering where from have you got the figure of 3 lakhs per acre?
But,
You have for your convenience sake divided. Learned single judge doesn't say he only awards 15 lakhs.
Molot, 3 lakh per
Each
acre
of the
is that.
petitioners.
Page 35, page 34, bottom, page 35.
35.
Page 34 at the bottom, Molot. But the question is, what would be the middle of the page?
34.
In the middle of the page, Molot, second paragraph. But the question is, what would be reasonable compensation? In finding answer to this question, the court is bound to take judicial notice of the fact that in recent years, there's a boom in land values. Though the rise in price of the agricultural land is not in the same ratio as the rise in value of urban properties, still there is considerable escalation in price of agricultural lands as well. Keeping
1 minute.
Yes.
3 lakh per acre.
Yes.
So you are saying 3 lakh is nothing. It should be 3 crore per acre.
But I wouldn't say that, Molot. Molot, if I'm left with the land, Molot, I'm more than happy to take. Molot, I don't understand, Molot.
You need not understand.
Molot, this issue of pricing of land would not have come up, Molot, if the assignment was ordered.
This is one and the same thing, right?
Which is extraneous to the pleadings in the writ petition as well.
The order 7, rule 7, what happens? Power of the court to mold relief extraneous to pleading. Supposing you say Tahsildar should be hanged, so court cannot say that he is required to undergo imprisonment for 7 years, extraneous to pleadings. This is power to mold relief is all. Don't argue, mister. If you understand, right? If you don't understand, too young to argue this thing, right? Power of the court to mold relief. What else? These are the only grounds. Yes, mister, you appear.
But I appear in 766.
His case.
Well, it's I appear
We
for
will
the
take
society limits.
Which case?
Well, item 75.
75. Yes. Which? What do you say? You are appearing for appellants.
Well, I appear for the
1 minute. You are appearing for appellants in WA 1232.
No, Millets. I appear for the writ petition.
One minute. He is appearing for appellants in WA 1232. We want to record the presence, mister. And nobody is appearing for anybody in the bunch except 6670 and WA 737. The respondent, we are asking about appellants. He is the only person who is interested in allotment, nobody else.
I am for petitioner in WP. Item 76.
76. What do you say?
That's my case is regarding with legal interference by the respondent authorities because it's a matter pertaining to the blood fees.
No. Illegal interference, that petition will be straightaway allowed by saying that they can't forcibly dispossess you, Land Encroachment Act or whatever act. They will take in action in accordance with law. That is, even if an encroacher cannot be thrown out, that's what we have held. 68 Supreme Court 620. So your petition is straightway disposed of. 76. Madam C 7. And who else for the petitioners?
Item 78, Milo.
Yes, please.
Yes, this is with regard to the houses, Milo. How this is constructed. Without any note in the 2000 is year 2000, without any notice, they wanted to dispose the petition.
78 dispossess, right?
Dispossess, yes.
That can't be done except in accordance with law.
Yes.
Whatever procedure known to law. So
Yes.
76 and 78 go, right? We are passing an order just now. Who else in the bunch?
Item 82, Miller.
Huh?
Item 82 with this, with regard to the allotment of the land to the ex-servicemen. Miller.
This is what is your grievance in 82?
Not we are in possession of the property, they are not allotting, Miller. We are not issuing any.
So like same, which WA 1232. 1232 is which item? 70?
71, Your Lordship.
So same in 71, right, mister?
Yes.
What else? Who appears? Which
Item
case?
number 84, Lordship. 84, item number 84,
80.
Lordship.
What is
Same apprehension, my lord, disposition of
disposition? That we are doing disposition just now.
developers.
The state government cannot take law in their own hands.
Developers.
Nobody. Yes.
77.
Item number 74. Panda certificate is not issued for the allotment land.
That is this thing, item number 71.
Please, Your Lordship.
Which other case?
Item number 77, my lordship.
1 minute, one is yes. 89, yes. Disposition. That is right now we will pass an order. Disposition. Then 77, Mr.
Raghavan, my lordship.
And
the writ petitioner, my lordship, disposition, my lord.
Disposition. All right. Yes. What else? That's it. Disposition we will pass an order. Give madam. Item number. No, madam. This see. 1 minute. Item 76, 78, 84, 84, 89 and 77. Grievances only with regard to disposition. 68 Supreme Court binds you. Besides that, in your this thing itself, you have sought the liberty to invoke provision of what? Land Encroachment Act. Right? Madam, the first 5 writ petitions we are disposing were grievances only with regard to disposition. No assignment. 77 is led by the 71 is led by that council. All others are following. Then we will hear respondents in those remaining. But first, you cannot say that even if they are encroachers, I will throw them out by this thing. You can't say. You have to follow 68 Supreme Court binds you. Yes.
Item 68, my lord, these houses, my lord, their government is already regularizing houses under says.
No, but your this thing is only with regard to, madam, give this 76, 78, 84, 89 and 77. Give files. Hurry, don't read out. Nobody is asking you to read out. We are just give. We have just now, they have told us. You give these files 76, 77, 78, 84 and 89. These are all writ petitions.
My lords, because it is a matter pertaining to Jawaharlal colony, therefore it is tagged with this writ appeal.
All right. Yes. Yes, madam, right. WP numbers for 5. 76, 77, 78, 78, 84 and 89. Writ petitions. in these writ petitions, comma, petitioners who are ex-servicemen claim to be in possession of various parcels of land situated at Jawahar Nagar village, Shivir, Shamirpet, We will also be happy. Why to exert ourselves, which we don't get in this thing, right? We are just doing our duty. Don't this thing. So matter. Finding, in case you find that you will take action only, they can't take. She has fairly considered this legal position settled by Supreme Court. We have given the 4 judgments of Supreme Court to say that they cannot be dispossessed. We have not relied on her concession. Right? So, which petitions are disposed of then? Mr. Item number? The 1 minute, 76, 77, 84, 89. Okay. 5. All right. So then now in remaining cases, arguments of appellants have been heard. This you want allotment of land, right?
May I only draw, the lordships are reserving, may I only draw your lordship.
Then not reserved. Now we will hear her, because in all the remaining cases, except 66, 70 and WA 737, all other cases you are leading the argument, right? By saying that I should have directed allotment of land.
But all cases are different, my lord. Some of them are
Different. They are adopting what can be done. They said same as, they are so impressed by your submissions that everybody said same as 71. Did you not hear? It's a compliment, Mr. to you. You should be happy about it. How well you have argued. Yes, Mr.
Well, it's item 75. Well, it's IPR for the society, the Jawaharnagar Cooperative.
Society you have allowed. There is no direction against you.
No, Millets, we had an interim order, Millets, and then subsequently, because the writ petition was dismissed.
No. The order is by single judge. You have also filed a writ appeal.
No, Millets, no. Part of the writ petition. Mine is item 75. Mine is a writ petition.
You have filed a writ petition.
Yes, my lords.
Against the order by single judge.
No, there is no order, my lords. I filed a writ petition saying that, my lord, the land is earmarked only for the, to be allotted to the ex-serviceman and it cannot be allotted to any other person. And in case it is allotted, so it should be cancelled.
So your petition will be taken up, you are petitioner in 32970, correct?
Let's clarify. What happened, my lord, when a matter came up, some other matter, not my matters, came before a learned single judge. The learned single, by then this writ appeal was filed by my friend. Then, my lord, the learned judge said all Jawaharnagar matters shall be heard by the division bench. That is
So
how,
they have come.
that is how they have done.
So
that's how
what do you want in this petition, Mr.?
Well, even my matter is, my lords,
What do you want?
well, I'll pass on the synopsis, my lords. The lords may hear me also.
No, you have to argue now. What is-
I'll argue, my lords.
Yeah.
I'll argue. May I pass on?
We
the
are
synopsis?
hearing the cases, no?
Yes.
Please argue. No, what is the prayer? Then we will hear
What
the
the prayer is, my lord, that they are trying to allot the plant, my lord, which is earmarked, my lords, to the ex-serviceman only. And it cannot be allotted to any other person because of the various DOs, my lord, that is issued by the government. Not the government.
So you are claiming that this land ought to be allotted to you, remaining whatever land, except in possession of the ex-servicemen,
should be
allotted to society. You will allot it to everybody else.
Initially, my lord, it was allotted to the society.
No, we are trying to understand your grievance, right? Then we will go to, this is your grievance, that whatever land, 5,000 acres, etc., excluding in possession of these petitioners, it should be allotted to you. You in turn will allot it to ex-servicemen. This is the grievance.
My grievance is it should be allotted to the members of the society.
Members of this. Yeah, it's a petition in representative capacity on behalf of members.
Yes.
Saying order 1, rule 8 sort of thing.
Well, yes.
That's saying that it should be given to you. But what is like, this is an independent case then?
Yes.
That will be heard separately along with senior counsel. 70, 66, 70, 75 and WA. 737 of 2018 shall be heard separately, right?
In 75 minutes, about 225 acres have been allotted to CRP.
It will be heard separately. So this is separate cause. Yes. This is now, all these remaining matters arise out of the direction where learned single judge has said that instead of, they are entitled to allotment of land. However, instead of directing that the lands be assigned, they have directed payment of compensation of 15 lakhs. He is against that order, saying that if everything, whatever was argued was accepted, the court should not have, this is foreign to the pleadings, 15 lakhs. And therefore, it can't be like this. Nobody, the petitioner did not ask that I should be paid 3 lakhs per acre. So this relief should not have been granted and only land should have been assigned. Later when we are putting, don't time and wait. We will record. Yes.
Would your lordships kindly give me 2 minutes?
No, nothing. You have argued, Mr. Watt. Now she has to argue. Thereafter, you will have an occasion to submit a rejoinder. Then 2 minutes there, 2 wide, 10 minutes you have. Let her argue. Yes, madam. What do you say? Madam, these 4 cases, you direct listing of WA, no, which is not listed. Searching, they have to search. Ask them not to go home till they find out the record. So 66, 70, 75 and WA 737 bar 2018. 737 will be printed separately like along with these matters. Remaining cases now, apart from what 5 we have disposed of, you write learned counsel for the appellant stroke petitioners have concluded their submissions, except these matters 66, 70, 737 and 75. 737 will come up. Yes, madam.
My matters will be heard today, my lord, or some other, it's 4:30.
Tomorrow.
Many time, lord, I'm ready.
It continues, right?
Absolutely.
We are trying our best to conclude it.
Very well, but only thing it's now 4:30, so.
You can go. We will hear her.
My matters be heard tomorrow.
Tomorrow. All his matter, your matter, two writ petitions and writ appeal. Will be, we have told that it will come up separately tomorrow. This bunch is being separately dealt with.
I seek my lord's.
Okay, yes. Yes. No, no, your rate appeal 737 is coming up tomorrow. No, madam.
Yes.
Ah,
737.
you tell Mr. Reddy, Registrar Judicial, you come when after we retire, you come there and I will instruct Mr. Reddy in your presence. Number this WP, it has to be found out and listed. Ah, yes, madam. What do you say with regard to their reply? Huh? Madam, again, same thing. You have argued several cases before
Yes,
us. Again, at least you are familiar. The young man is not familiar with the court, so he argued in his own. But you know what? Please, we request you to elaborate your submissions. First, state your submission 1, 2, 3, 4, and then elaborate. We will go to everything: single bench, division bench,
Very well.
everything.
My lord, my first
Submission is what?
My first submission is, my lord, this is the land which was.
But they are only
Sorry.
lighter vein. Counsel for appellants and petitioners have only one submission. So you can't have more than one. All right.
My lord, this is the land, my lord, which was originally designed for, my lord.
No submissions. One, number one.
My submission is, my lord, the land which was given.
And in occupation of petitioner.
And in occupation of these petitioners, my lord, petitioner number 1 is not in possession of the land, my lord, in writ appeal.
No, that is
1323, which it covers your lordship's order, my lord, but my submission is, my lord, petitioner number 1 is an encroacher. In the
Maybe an encroacher. Then also we have said that.
Yes, and petitioner number 2's land, my lord, has already been allotted.
We understand
Yes.
there is an order in their favor by single bench holding them entitled for allotment of a land.
Exactly. Against which, my lord, they sought an interim order from this honorable court after filing the writ appeal. Because of the interim order, my lord.
No, so therefore, madam, please,
Yes.
you have argued the cases before us.
Yes, your lord.
And therefore, we are asking again, requesting you to tell us what are your submission, then we will elaborate.
My submission.
First submission is what?
My submission is, my lord, the entire extent of the land to the extent of 5,977 acres.
1 minute, entire extent of land.
5,977, my lord. Is a government land. There are my.
They are not saying it's our land. That's why they are seeking assignment from you.
No, my lord.
They assume that it is a government land, and what they are contending is that we are entitled to assignment.
My lord, they are entitled.
Why they are not entitled to assignment?
My lord, initially when the society was formed, my lord, there were 149 beneficiaries identified by the society.
When was it formed?
My lord, I. Nine one 1958.
Yes, madam.
My lord, the land was taken over by the military estate, my lord, on 23/7/1951.
No, government land. That's what first thing you told. That
That is dated 9/1/58, my lord, the society which was formed,
society was formed on
9/1/1958. The society was, my lord, Jawahar Nagar.
9/1/58.
Yes, my lord. The name of the society was Jawahar Nagar Cooperative Land Colonization Society.
Jawahar Nagar Cooperative
Land Colonization Society.
Colonization.
Yes, my lord.
Ah. Yes,
On 9/1/1958.
correct.
They were asked to give the land, my lord, to an extent of 2.5 acres wet.
They means who?
They means this society, my lord, was required to give 2.5 acres wetland and 5 acres of dry land.
No, society means, did you allot any land to society?
Yes, your lordship.
When did you allot, madam? Prepare. We will continue tomorrow. Prepare this time you instead of relying on vacate petition.
Very well.
Right. Subject to, we will list for further hearing tomorrow. You write submissions concluded. How learned? Write in paragraph. Then say what grounds you are selling those, you are in your appeal.
Yes.
What grounds you are selling those findings, and what is your submission in these writ appeals, that why they should not be given, why the land should not be assigned to them. Tomorrow, separate. So that will be easier, madam, if
Yes,
you do it that way.
Yes, ma'am.
Yes. Which case? You are for respondents. We will hear you after madam concludes. Yes. Please give it, pass it on. Please pass it on. We will hear you tomorrow after she concludes. If time permits, after she concludes, we will hear you.
With your lordship's kind leave, sorry, your lordship. 79 and
Half an hour's time. Half an hour, 45 minutes. We again conclude the dictation. Yes.
79 and 83 are dispossession matters, your lordship.
79
and 83. I am for petitioner.
So it has been done, right? Not done. So included then.
Acho.
Oh. Where were you?
No, just I was in 20th court, your lordship.
So this is the advantage.
sorry, your lordship.
No live streaming, right? You saw in the court, dispossession matters are being disposed of, so I should rush to court hall 1.
I was informed by my colleague. That's why I am sorry, your lordship.
No, not sorry. We thought that it's because of live streaming you could see in court hall that dispossession matters are being decided in court hall 1, so I should go. Which lighter vein, Mr. Yes, to be serious about.
79 and 83. 79
yes.
and 83.
So you will, next paragraph, you will incorporate petitioner in WP number so and so is claiming so and so.
Much over.